will be discussing essentials or legal rules as to consideration. The first essential, the consideration must move at the desire of the promisor. This means the consideration must be given or must be requested at the or given at the desire of the promisor. The first essential ingredient of the definition of consideration is that an act or abstinence constituting consideration must have been done at the desire or at the request of the promisor. It means that the consideration must proceed at the desire of the promisor. When it is requested by the promisor, then and then only it must be given. An act done at the desire of the third person will not constitute a good consideration within the meaning of section 2D of the act. The definition in section 2D clearly emphasizes that an act or abstinence which is to be consideration for the promise must be done or promised to be done in accordance with the desire of the promisor. If such consideration is made at the will of third party or at the will or request of the third person or without the desire of the promisor, it will not be a good consideration. For example, A renders some services to B without his request. Latter, A cannot demand or ask consideration for his services. Another example, A saves B from drowning in the river without being asked to do so. A cannot demand payment for his services. It is gratuitous act. As you all know that if the act or abstinence is gratuitous or voluntarily without being asked to do so, in that case, it is not a good consideration in eye of law. So, whenever the act is done, that must be at the request or at the desire of the promisor. Another example we can discuss here, A sees B's house on fire and helps in extinguishing the fire. So here he cannot demand payment for his services because B never asked him to come for the help. Here the whatever the act was done by A, that was voluntarily act or gratuitous, and therefore he is not liable to get consideration. On the same point, we are going to discuss the case law of Durga Prasad versus Baldev. The consideration for the promise had not moved. In this case, the consideration or whatever the act which constitute consideration for the promise had not moved at the desire of the promisor, but at the desire or at the request of some other person, and it was held that the same was not a sufficient consideration to support the promise. The fact of the case, the plaintiff A constructed certain shops in a market at the desire of the collector of that place. Subsequently, the defendant B occupied one of the shops in the market. Since the plaintiff A had spent lot of money for construction of the market, the defendant B, in consideration, made a promise to pay the plaintiff A commission on whatever the articles sold through their agencies or in the shop of the defendant in that market. The defendants B, afterwards, the defendants B failed to pay the promise commission to plaintiff, and therefore plaintiff had filed a suit. In an action by the plaintiff A to recover the commission, it was observed that the consideration for the promise to pay the commission, because here the defendant he had promised to pay commission on the article sold in the shop. So the promise to pay the commission was the construction of the market by the plaintiff A. Such construction had not been done at the desire of the defendant B, but that was done on the order of the collector to please him. It was held, therefore, that since the consideration did not move at the request, or the consideration did not given at the desire or request of the defendant B, the promisor in this case, this did not constitute a valid consideration, and therefore the defendants, that is B, were not liable in respect of the promise made by him. Next essential of consideration or legal rule as to consideration is consideration may move from promisee or any other person. So according to Indian law, consideration may be given by promisee or any other person if the promisor has no objection. Means here, for example, if there is a contract between A and B, so here B is a promisee, A is a promisor, and B is a promisee. So consideration may be given by B, that is promisee, or any other person, provided that if promisor has no objection. So Indian law is wider than English law. Under English law, consideration must move or must be given by promisee only. So, example, A promises to give his watch to B, and a consideration of rupees 2000 for the same is given to A by X and not by B. Such a contract will be valid in India under section 2D because it clearly provides that at the desire of the promisor, the promisee or any other person may provide consideration. So here, if there is a contract between A and B, C being a stranger, he also provide consideration for the contract between A and B. On the same point, the position in India may be well explained by referring to the case of Chinaya versus Ramayana. In this case, an old lady granted an estate. She granted gift to her daughter. Here in this case, daughter is defendant with direction that the daughter should pay an annuity of rupees 653 to A's brother, that is to daughter's uncle. And here in this case, A's brother is plaintiff. On the same day, the defendant, that is daughter, made a promise in writing with the plaintiff, that is A's brother, that she would pay the annuity as directed by A. The defendant, that is daughter, failed to pay the stipulated sum, or she failed to pay the annuity to A's brother. So here A's brother, that is plaintiff, file an action to recover the promised amount. So in an action against daughter, against her by the plaintiff, she contended, that is daughter contended, that since the plaintiff themselves had furnished no consideration, here her contention was that uncle or A's brother had not given any consideration, and therefore there was no contract between them because she promised to pay, but there was no written promise by uncle, and therefore A's brother, or they had no right of action. That was her contention, the contention of the daughter. The Madras High Court held that in this agreement, that is between the defendant and the plaintiff, that is A's brother, the consideration has been furnished by defendant's mother, that is by the mother of the daughter, and that is enough consideration to enforce the promise between the plaintiff and the defendant, because here the law, as per Indian law, the consideration may move from promisee or any other person. So in this case, here already the consideration for uncle's promise or A's brother moved from an old lady, and there was no need of fresh consideration in this case. Third essential or legal rule as to consideration: consideration may be past, present, and future. When in return for the promise, the promisee or any other person has done or abstained from doing, the consideration is past. Does or abstains from doing, the consideration is present. Promises to do or abstains from doing, the consideration is future. Abstains here means that not doing an act, that is known as abstinence. Whether the consideration is past, present, or future, it is essential that it must have been given at the desire of the promisor. Let us discuss past consideration. It means that the consideration for any promise was given earlier and the promise is made thereafter. So it is of course necessary that at the time the consideration was given, that must have been done at the desire of the promisor. Example: I request you to find my lost dog. After you have done means after the act has been done, I promise to pay you rupees 100 for that. It is a case of past consideration. Means here already the act of finding the dog is done in the past, and thereafter if I promise to pay you rupees 100, that is a case of past consideration. For my promise to pay rupees 100, the consideration is your efforts in finding my lost dog, and the same had been done before I promised to pay the amount. In this case, the consideration has been given at my request, because it is only when I requested you that you found the dog. This constitute valid past consideration under section 2D, and therefore the promise is enforceable. So in case of past consideration, the act is done in past at the request of the promisor, and thereafter the promise is made. Present or executed consideration: when consideration is given simultaneously with the promise, that is at the time of the promise, it is said to be present consideration. In a cash sale, for example, consideration is present or executed. Example: B buys an article from shop and he pays the price immediately or simultaneously. The consideration moving or given from B is present or executed consideration. That is, customer pays the price immediately for the goods he buys from the seller. So this is the case of present or executed consideration. Future consideration, or it is known as executory consideration: when the consideration is to move at a future date, it is called future or executory consideration. In a contract, a consideration may be executory on both sides. In short, when consideration from one party to the other is to pass subsequently to the making of the contract, it is future or executory consideration. So let us examine this with example. S promised to deliver certain goods to B af- after a week. B promises to pay the price after fortnight. The promise of S is supported by promise of B. So consideration in this case is a future or executory consideration. Fourth legal rule or essential as to consideration. Consideration need not be adequate. Consideration must be something of value. Consideration, as already explained, means something in return of something. This something in return need not necessarily be equal in value to something given. The law simply provides that a contract should be supported by consideration. Means here consideration may be adequate or inadequate, but there has to be some consideration, or every agreement must be supported by consideration. The court or the law will not see that whether it is adequate or inadequate. It is for the party to see whether whatever consideration he is accepting, whether it is adequate or inadequate. Only the court will consider whether the consent is a free consent or not. If the parties to contract has no problem or objection in accepting adequate or inadequate consideration, law will not go into it. So consideration need not be adequate. If it has some value in the eye of law, it is enough, and the contract is valid. For example, sells his cycle worth rupees 1000 to B for rupees 100 only. It is valid though the consideration is inadequate, that is not sufficient. There must be consideration. It is immaterial that it is adequate or not. Because here, if the party's consent is there, in that case, adequate or inadequate consideration, the court or the law will not look into it. Next, essential consideration must be real and not illusory. Although consideration need not be adequate, it must be real. Real means it has some value in eye of law, competent, and some value in eye of the law. It can be in kind, that is in exchange of other thing. It must be real. Example, car in exchange of a piece of land. So the consideration to be valid must be real, and it must have value and must not be illusory or sham. The valuable consideration may consist either in some loss or detriment suffered or undertaken by the other. Example, the following are considered to be not real consideration because of number one, physical impossibility. Example, A promises to find lost treasure by magic. Treasure means khajina. The consideration is said to be impossible because here finding a lost treasure physically it is not possible, and therefore this is known as physical impossibility. Another example, A promises to put life into B's dead wife if B pay him rupees 1 lakh. A's promise is physically impossible of performance. It is illusory or it is not real consideration. Another example, A engages B for doing a certain work and promises to pay a reasonable amount or promises to pay a reasonable sum. There is no recognized method of asserting the reasonable remuneration. So the promise is unenforceable as consideration in this case is uncertain. Next is legal impossibility. We are discussing essential when consideration is not real. legal impossibility. Example, A owes rupees 500 to B. He promises to pay rupees 100 to C, the nephew of B, who in turn promises to discharge A from the debt. This is legally impossible because C cannot give a legal discharge for a debt due to B. Illusory consideration. Or another example, we can legal impossibility. For example, A already married to B. He promises C that he will marry C in future. So again, this is legal impossibility because if the spouse is alive, he cannot promise. He cannot make such promise. So here consideration is not real consideration. Illusory consideration. Again, illusory consideration does not amount to a valid consideration. Consideration is illusory, means when it is not real, if it consists in a promise to perform a public duty or to perform a contract already made with the promisor. For example, A promises B, a witness in a trial, a certain sum of money. B had already received a summons to appear before the court of law or court of trial. The consideration is not real because already he is under obligation or he is under legal duty to appear once he received the summons. So here in this case, the consideration is not real consideration. Next essential consideration must not be illegal, immoral, or opposed to public policy. Section 23. The consideration given for an agreement must not be unlawful. Where it is unlawful, the court does not allow an action to the agreement. Thus, a gift to a concubine, that is to prostitution, for past cohabitation is held to be no good consideration. For example, if A says that he will sell his house to B and B agrees to purchase in exchange of his daughter is void, being immoral and opposed to public policy. An agreement for illicit cohabitation being immoral and illegal, therefore unlawful. Thank you. Here I have completed legal rules as to consideration.